Welcome to day 5 of Family Mediation Week. In today's webinar, we are going to discuss how we can use neutrals within mediation and adapt our way of working. For those of you that don't know me, my name is Sarah Manning and I am the chair of Family Mediation Week. I'm also a partner at Hall Brown Family Law, who are sponsors of Family Mediation Week, and I practice as a family solicitor and mediator in both children and financial matters. I'm also a trained hybrid and child inclusive mediator, and I've now practiced as a mediator for 11 years. I also have with me Suzanne Smales. Suzanne is a qualified barrister both in the UK and Australia, and upon moving to Australia in 2010, she took the opportunity to re-qualify as a barrister, but also to concentrate on qualifying as a mediator and a collaborative lawyer. Since returning to the UK in 2022, Suzanne has been a passionate advocate of non-litigious dispute resolution, which is where I met her through discussions about that process. And most recently, Suzanne has moved back to Australia, Melbourne, this time where she hopes to continue promoting non-adversarial dispute resolution and also a family law supervisor. So Suzanne is in Australia now while we're doing this webinar, which is lovely. I also have with me Adam Green. Adam is a chartered and certified financial planner at Mazars and works with business owners and families alike. Adam works collaboratively with clients to make better and more informed financial decisions as part of the separation process. Mazars Financial Planning is also a sponsor of Family Mediation Week, so thank you for that. For those of you that are thinking what is a neutral, I'm going to start off the presentation and then we're going to move on to Adam, and thank you for sharing the slides, and then we'll move on from them. There will be a discussion at the end and some time for general discussion. So what is a neutral? As a mediator, I'm a neutral within the process, and my role is to facilitate discussions between the parties and without imposing my own views and beliefs. I can provide legal information where required for the parties to make their own informed decision. And even though I am a practicing solicitor myself, I cannot give that advice. As a mediator, I must also act impartially at all times and avoid any conflict of interest. And it's also always important that a mediator does not mediate in a situation where they have acquired relevant information about the parties. And I always start off with a conflict check at the start of instructions. So as I'm a qualified solicitor and a mediator and do the dual roles, it's always important to me that I'm not mediating on any of the cases that my firm will also be dealing with. A neutral can also come in different forms to assist a separating couple to resolve their disputes within the mediation process. As the mediator, any professional coming into the process would need to remain neutral, and they are not there to act for one person over the other. And again, it's about providing information so the participants can make their own informed decision. So even if a solicitor came and got part of the mediation, they wouldn't be a neutral, they'd be representing that other person. It's important to note that if separating couples decide to engage in mediation, that the mediator remains in control of the mediation process, even if other neutrals join that process. I cannot stress to the lawyers that are present today how important the mediation information assessment meeting is within the process. And following the new standards that came into effect in 2022, all mediators must now obtain information from the participants about their circumstances and the issue arising from separation, provide participants with sufficient information about mediation and other resolution processes so that they can make an informed decision of the process they wish to take, assess the safety and suitability of mediation, and also to discuss where possible, identify with participants their next steps, including the value of seeking legal advice. You're also required as a mediator to assess what other assistance may be needed to resolve the matters. For instance, if there's a pension to be divided, then we may need to consider early on instructing a pension on divorce expert and seek advice from an independent financial advisor, which Adam will touch upon more later on in the presentation. There may be a business and I need to consider if the business needs valuing, and we need to consider at that stage the timescales and things and how long it takes to get these about that at the very beginning of your mediation information assessment meeting. If it's a children matter, we also need to consider, do we need to be using a child inclusive mediator to speak to the children? Is it necessary for an independent social worker to work with the family? And we can think about that at that time. In my MyAMs, I explore and discuss with each of them separately as to what other neutrals we can use and to bring them in the process. So sort of managing their expectations at the beginning and talk about what issues. But like I say, each assessment meeting is different. Mediators often call this signposting, and it's something that needs to consider in the MyAM. It may be that people need emotional help from a divorce coach or a domestic abuse agency, or if they don't have a solicitor, then I always recommend that they do have a solicitor along the process, and it might be that we need to signpost to them. Mediation is not a process that replaces legal advice, and I always flag that up in my MyAMs and the benefits of having a joined up approach. And I explain the different skill sets of the different people and different roles of how that can help them reach a resolution. The mediator at this stage needs to work out what is needed, and active listening is really key here, and having them separate confidential meetings to find out what the issues are. One of the benefits, I think, is as a mediator, you do see the situation from a 360-degree angle. There's always two sides to every story. And when I started training as a mediator, and it sort of changed the way I was a solicitor, because when you're listening to one person, it always astounds me that you then see the other person the day after, and it's a completely different version of events. And sometimes I try to think about that in my work as a solicitor. There's always two sides. There's no smoke without fire, and sort of think about that. I can hear as well what people's worries are, concerns are, and then we can try look at addressing that. And more often than not, if one person's not being actively involved in the finances and the relationship breaks down, the trust and confidence breaks down, and they start to doubt the information that's provided. And sometimes just getting a neutral to value the house, say for instance, as with a single joint expert, can relieve this doubt when discussing when discussions take place. Or it might be that they want a forensic accountant to look at the information that's been provided, because they don't feel they're able to do that, especially if there's a business owner and it's the husband who owns that business and it's information provided, and wife feels that she's not able to look at that in that situation. My role as a neutral in the process is to help them reach a resolution. And it's not about winning or losing in mediation. Both come away with an outcome that they can live with. And I always make this clear in my MyAMs to manage their expectations. Mediation is so adaptable that it's also possible to have solicitors involved in the process, which in turn can assist in the instructions of neutrals. In my role as a hybrid mediator, I may have separate sessions with professionals only to help things move along, and include solicitors and any other neutrals involved, including myself. It's always good to address, I always say, the elephant in the room, and consider what is stopping the reaching a resolution, and to consider as a neutral person how we can overcome this. It's important to acknowledge that no two families are the same. So going back to the assessment meeting, a joined up approach sometimes is required. It's not always required, and a lot of my mediations, I do the more traditional mediations where it's just myself and the separating couple in a room together. So we're not saying today that you always need these neutrals, but I think with the new family procedure rules that are coming into place in April, to encourage people to consider non-court resolutions, I feel that we're going to see more cases that are complex coming through to mediation, and we need to adapt as a way to help people with the right skill set into the mediation to make it more of a success than parties having to turn to court. So we've just gone to the next slide. I'm just going to run through. So what are the different types of neutrals? So this is not an exhaustive list, and you might be thinking there's a lot more than that, but I just thought to run through some of the main ones that I've used in my mediation sessions. So in terms of financial matters, a financial advisor and a pension and divorce expert is key in a financial one, especially if it's high net worth assets or complex, and they've got pensions over 100,000. Adam again will touch upon this, but just to say how I do consider that, and sometimes in my mediations I do a planning meeting first to talk about financial disclosure and just give that legal information, and having someone like Adam there with me at that initial session can really help get everything in place, and Adam can talk about what value he can add and information. I've used as well accountants and other tax experts. It's really good to have an independent accountant, especially if you've had a business value from the business's own accountant, which can cause issues. And having somebody neutral come in they can come into the process. The business owner, husband or wife, can explain to, you know, the account expert what's been going on, and it can be as bespoke as you need it to be, really. I've put divorce coaches there because it is something that I've talked about with divorce coaches and questioned whether they're a neutral. And I did a session on a webinar on Monday with Sarah Davison, who didn't think it's right to be a neutral, and you need to be there for one person. So each person's different, and it might be that the divorce coach that you work with is able to come in as a neutral to offer that emotional support to both. It's each individual, and I think a therapist as well would be quite good if they need to come in to give some information about what they've done to try help things move forward. Value of properties and companies, that, you know, to get the neutrals to come in, we often need somebody to do that. And I've put there a forensic accountant that might need to look through bank statements, what's gone on in businesses, and an early neutral evaluator as well, which is a retired judge or barrister coming into the mediation process to give an indication. So as a mediator, I can't give legal advice. The solicitors are there to support their clients. So the early neutral evaluator will come in to give an indication, a bit like a private FDR, which can help close the gap if there is a dispute. In terms of children matters, having an independent social worker can help with the children's views. Again, the early neutral evaluator can determine on children matters. And also, if there's a therapist that's working with the children, they could come into the mediation to give information on what's the discussions that have taken place. If I'm using neutrals in mediation, I tend to assign people up to hybrid or integrated mediation process. And the main difference between these two models is that the mediator can hold the confidences, and they do not need to be shared. Information does not need to be shared with the other participant in separate meetings, which can therefore aid the mediator in assessing the participants to reach a decision. Sorry, next slide, please. In more traditional mediation sessions, any information disclosed needs to be shared with all the participants for the mediation to continue, which sometimes can hinder the process and the parties' ability to have trust and confidence in the mediator. The hybrid mediation does allow discussions to be explored with the mediator, with the client feeling at ease that certain information is not going to be passed on. And I think as well, it's good if we're instructing neutrals with the hybrid process to have professional only meetings with the solicitors to look at how we're going to instruct them. I'm just going to run on to a few sort of case examples that I've used here, just as by way of an example. I appreciate I've just done a whistle-stop tour to neutrals, and today's more about a discussion. But if anyone has any questions, please pop in the chat box and we'll come to it at the end. So in terms of an early neutral evaluator, I've done this on a case, and we recorded a webinar last year with David Emerson. It was a real life case we talked about where David Emerson was the mediator, and we had his honour Judge Waller as the early neutral evaluator. He was able to determine on children and financial matters, which really helped us reach a resolution. The mediator helped do a neutral brief, which was really good at assisting and not getting us positional. And then there was the opportunity for husband and wife to put forwards their sort of arguments or skeleton arguments, so to speak. It's with the early neutral evaluations that I've done a few times, it can be as formal as informal as you want. So it can take more of the form of a FDR, a private FDR, or it can just be that it's dealt with on paper. It depends on the issues and the individual session. So again, it goes back to how important the assessment meeting is, constantly doing that assessment, and also the professional only meetings with the solicitors. You need to make sure that they're supportive of that. Another case that I've dealt with is forensic accountant looking through the finances, and in this case it was where the wife has not been really taking much input into the finances, quite complex, and because there'd been trust had broken down in their relationship, she just wanted someone else to come look independently at the information provided that it was correct. We got a forensic accountant to come in who took part in the meetings, and he said everything looks above board and happy with the questions. So then the wife felt comfortable to then go on to talking about making to agreeing some proposals and looking at settling. The other thing that does really help, I'll just go on quickly about if you're instructing like a actuary to come value pensions, helping with the letter of instructions can really help. I've had a few mediations where the clients have decided, oh, we're having a business valued, or we need an actual report, that it's gone back to solicitors, and months and months and months have gone by where things haven't been as proactive. The letters have gone back and forth or not agreed, and it's delayed the mediation process. So what I tend to suggest is that get the solicitors to come into the mediation process. In that our session, we talk about just getting the letter of instructions done. We agree in that session it's done. And I think, again, I like to go back and manage the process as the mediator to get a resolution. And sometimes things can drag on a little bit, and most people who come to mediation want to do it quite quickly, which is one of the benefits as well. I do use financial advisors, and me and Adam have got a case that we're dealing with on Monday where he's coming into the first session for us to gather information, have a bit of a planning session, which is what I touched upon before. And I'm going to pass you on to Adam now, who'll be able to go through a little bit more what he does. But financial advisors is probably the most common neutral that I use within the process. And again, it's just giving out that information and getting the right experts in place to have more of a joined up approach. So thank you, Adam. I'm going to pass you over to you now to just go through your part, and then we'll be in a discussion afterwards. So if you have any more things that you want to ask or questions that are coming up, please pop them in the Q&A box. Thanks. Over to you, Adam.
Thank you, Sarah, and good morning, everybody. As Sarah mentioned at the start, I'm a chartered and certified financial planner at Mazars Financial Planning, and we're one of the proud sponsors of Family Mediation Week. So I'm going to spend a few minutes this morning with you talking about who financial planners are. I use the term financial planner, very similar to a financial advisor, so the terms are interchangeable for the purpose of this morning, but I will refer to myself as a financial planner. And importantly, how they can assist in a mediation process as a neutral. So first and foremost, so who are financial planners? I would say that they are there to help individuals make better quality, more informed decisions when it comes to personal and family finances. In the context of a mediation process, they act as an impartial party who can present financial information in such a way that both parties understand and in an objective manner, i.e. it's factual information on which decisions can be made. Now, this is my own personal view, but I would say they should be chartered individuals who are experts on personal finance and are trained to guide and help people navigate the complex world of personal and family finance. I mean, typically, family finances can be a tricky subject to tackle at the best of times. So being there as part of a separation process, which can already be emotionally challenging, financial planners can help to alleviate the stress and concerns that come with making financial decisions. So what do they do? Well, being part of a mediation process, the financial planner can, via the help of a lifetime cash flow forecast, which I'll come on to in a moment, present a family's financial position in an easy to understand way. By mapping out a current and potential post-separation financial future for each party, they can present a neutral position that shows how a particular split of financial assets leaves each party. This will enable fair and equitable decisions to be made when agreeing on a settlement. Because the information that's presented is factual and it's not biased towards one party or another, it's fundamentally the pot. This means it's difficult to contest whether one split of assets is fair on one party or another, because it can be presented right there in front of both parties for everybody to see. Not only can a financial planner present the financial position in a way that helps make more informed decisions, they also bring their expertise and knowledge about financial products and regulations. This can be very useful when discussing the split of assets such as properties, mortgages, pensions, which is a big one, and investments. All financial assets carry their own features, benefits and drawbacks, tax implications. So having an understanding of these can help a couple come to a kind of fairer outcome for both parties. It's really easy to miss small pieces of tax for a particular type of asset. A really good example of this that I worked on a case previously, talking about pensions, and we could spend a long time talking about pensions because of how complex they can be. But I was presented with a situation. There was a settlement there was an offer on the table for a husband to his wife who were separating, and he had a couple of pensions, one that he'd accessed and one that he hadn't. The kind of pension credit that they were suggesting would go to the wife was from the pension that had been accessed. Now, that essentially meant that the credit that the wife would have received, she wouldn't have had an entitlement to a tax-free lump sum. And I kind of went back and said, okay, well, are you aware that this is the case? You wouldn't have a tax-free lump sum. They didn't know. You wouldn't know, because to them it was just two pensions. But by just understanding broadly what I was kind of looking at, we could ask the question, and they could go back and get a different outcome. So financial planners can help to answer these questions. They can act as a sounding board for decisions or ideas that a couple might try to agree a fair split of assets. They can also give a party an idea about what their financial future will look like, on an individual basis. So they can feel more comfortable accepting a particular split of assets, safe in the knowledge that, they're going to be okay afterwards. This can help to take some of the uncertainties away post-separation, which often hinder decisions being made and agreements happening. So when is a financial planner used within the process? I mean, there's no exact response, but I would really say is, as early in the process as possible. The reason being, we want to get on the front foot when helping a couple fully understand their financial position, and therefore how this might be split as part of a separation process. Being involved in collaborative meetings with a mediator and potentially legal consultants mean that the right experts are in the room to help guide conversations and highlight any key considerations. I tend to find the earlier we get involved with the process, the more effective a job that we can do, not least because it gives us a chance to kind of build rapport and trust with a couple. And I think that's absolutely crucial when in facilitating a good conversation about finance. I appreciate that can't always happen. People might be reluctant to involve more professionals and incur more fees. However, my view is that this does allow us to do our job to a far higher level. Because if we're brought in later, some decisions might have already been made, which may have already taken some time to come to. If we come in as a financial neutral and say, oh, well, actually, have you thought about the tax implications of doing this? No, we've not. It might change the decision. We could have addressed that up front if we'd have been there earlier. Ultimately, I think by being involved early, you can save money and, importantly, time in the long run. So how are financial planners engaged? Typically, it's a standalone engagement covering the attendance of mediation meetings, ultimately as many as required, and the cost to run through a comprehensive cash flow forecast. Typically, it's a fixed fee basis broadly, and it depends on the complexity of the financial situation. I'd say we're always happy to have an initial conversation. Sarah's mentioned that we're meeting somebody on Monday. We're always happy to have an initial conversation at no cost to a couple to help them understand whether they would benefit from engaging financial planner as part of the mediation process. Next slide, please. So lifetime cash flow forecasting. So you may have already seen a colourful graph that looks something like this one, but I think it's worth giving an overview of it today, as I really don't believe that the importance of a cash flow forecast can be underplayed during a financial planning exercise, specifically during a separation. To put it very simply, the use of a lifetime cash flow forecast can help to answer the key question that most individuals want to know the answer to as part of a separation. Am I going to be okay? The cash flow forecasting, or modelling as it's sometimes called, can be used to map out the financial future of a couple by inputting a number of key pieces of financial information. The information that's required to build a comprehensive cash flow forecast is very similar to that needed as part of the calculation of a settlement agreement. It considers assets available, the matrimonial home, savings, pensions, investments, other properties potentially, as well as how much somebody thinks they will need to live on. This can include costs of childcare, educational costs, retirement spending, things like that. I would say the idea of what an individual needs to live on, so the amount of money they need to live the life that they want, can often be a source of disagreement in a separation process. So having an expert there in the room to discuss this with them can help each party come to an amount that's right for both. Often we might go into a breakdown of spending, what's considered necessary, what we would call basic living costs. And then we can look at what people need to enjoy themselves or discretionary spending. All of the financial unknowns that are often the source of debate during a separation process can be plugged into a cash flow forecast live in a mediation meeting so that a couple can see the impact of various agreements, various splits of assets can have on the other individual. Said it already, but this makes it difficult to contest when the figures are right there in front of both people to see. So the example that I've got on screen for you there is a very typical example. This particular client, they had a grown-up children. The husband was the higher earner. They had the largest share of the assets, particularly had a defined benefit pension. So a typical client scenario. Now, we considered ways that the assets could be split on separation, and we agreed an amount via the conversation that the wife would need to spend to live on and afford a mortgage on the property she wanted to remain in, and what she could reasonably earn until her age 57. So in the example that's on the screen in front of you, the wife said, well, I want to continue working. She was self-employed until about age 57. And then at that point, I'd like to look at doing something else. So we put in to the model how much she could reasonably feel that she could earn, what her savings would be, the amount of pension that she would receive, and then we could put that in, model it forward and see how sustainable the share of the husband's pension would be and whether it would allow the wife to meet her objective of stopping work at 57. So the level of spending in this particular example is relatively modest, but it was agreed by both husband and wife. And we could also model a maintenance payment, which is the kind of purple bar on the left-hand side of the graph that the husband would pay to the wife until her age 57 to see if that impacted her financial position and, importantly, how it left her after that maintenance payment stopped. We could also include mortgage payments on the main residence, as this is something that she would have had to have taken out and that she did take out as part of remaining in the property. So we could look at, is the wife able to stay in the property? What would a reasonable mortgage cost be? Would that be affordable for her? Can she still retire at 57? And we could look at all of this with them both in the meeting. Now, there are questions along the way about pension. And I've mentioned previously that the husband had a defined benefit pension. So I had to spend a little bit of time with them both explaining that, how does a defined benefit pension work? And really importantly, if the wife was to receive a pension credit from that pension, how that would actually be a different type of pension, defined contribution pension for the wife. That works in a very different way to a defined benefit pension. Now, I was there, so I could explain that to them both there and then. If a financial neutral hadn't have been in the conversation at the time, that may have been missed. It might not have been thought about till later on. But just by being there, we could signpost them, give them that information to say, okay, actually, this is how a split's going to work on the pension basis. So just as a very quick reminder, defined benefit pension pays guaranteed benefits, whereas the pension credit to be awarded to the wife doesn't carry those guaranteed benefits. it would be an invested pot in the wife's name. That then brings conversations about the wife's attitude to investment risk into the conversation and what she might reasonably be able to achieve on those invested assets over the course of the rest of her life. All things that we needed to consider to understand how much of the husband's pension might be required. Now, you potentially or would likely get a pension on divorce expert report done to confirm all of the figures, but we could just look at different amounts in that first meeting to see the impact. Now, all of these figures and all of these factors were considered and built into the cash flow that you can see. I think it would have been really difficult to achieve an outcome that suited both parties if the cash flow forecast hadn't been there, because otherwise you're just thinking about different amounts to be passed from one to the other. You can't really see the impact that it would have. I mean, as far as I'm concerned, cash flow forecasting forms part of most successful financial plans. It's very difficult, I find, from experience, to make informed long-term financial decisions without one. Next slide, please. So I wanted to touch on the other services that a financial neutral can provide. This might not necessarily be a financial planner. Sarah's mentioned as well, obviously, about other types of neutrals that can be involved, accounting, tax professionals, but I thought it was worth just touching on some of the other areas that a financial neutral can provide value within a mediation process. So tax advice is a big one. Clearly, when you're splitting assets, or potentially clearly when you're splitting assets, there can be tax implications. If property is split or a portfolio of properties is split as part of the pot for a separating couple, there are tax implications to be considered. Advice around the transfer of shares in a business on separation is a highly technical area, may well need a qualified accountant to sit in to discuss how that would work, because it can get very complicated, and a specific tax professional being involved can help answer questions about how shares in a business can be transferred. What you obviously don't want to do is spend a lot of time agreeing how assets are going to be split, and then that's enacted, and then there's tax implications on one of the individuals or potentially both that hadn't been accounted for. And actually, this resolution that you'd come to actually no longer makes sense because of a piece of tax that may have been missed. It's something that we've seen, particularly on the split of properties within a couple's asset base. The same applies to trusts, particularly where there's multiple beneficiaries. This can again get very complicated very quickly. So having a financial neutral who understands trusts, beneficiaries, how the split of assets within a trust can work from a legal and tax perspective can be very, very useful. I've seen various occasions where trusts have been split, beneficiaries have been changed that actually shouldn't have been as part of the separation process. It takes more time and cost to undo some of these decisions. The same also goes for more complex pensions, defined benefit. I've put small self-administered scheme type arrangements, although they're not typically, or a SAS arrangement as they're often known as. They're not as common anymore, but they're also complex structures. So having a professional there to at least talk about how they work and the implications of moving them can be helpful. Financial neutrals can also help with either the completion of a Form E, so gathering all of the relevant financial information. A financial planner, advisor can write off with something called a letter of authority, effectively allowing us to gather information on the client's behalf from the product providers that they may have. We ultimately know what we're asking for, so we can ask the right questions to get the right answers needed for a financial information based on the assets that a couple have got. We can also complete an assessment formies as well to do a financial analysis. We can also review a pension on divorce expert report. I'm sure you've seen many of them. They can often come back being very long, difficult to understand. We can go through them, help a couple say, look, these are the important features. And again, use the cash flow forecasting, input these figures that might come out of a POD report into a cash flow to kind of map it out, give it some context to the individuals. And a final point I've put there, future wealth management and planning. Now, this is often a point, really, this is post-separation, settlements all been agreed. This is often a point where people think financial professionals actually then get involved. Now, only when there's time to kind of manage money. It's such a pet peeve of mine that, you know, a financial advisor or planner has to get involved only when there's money to manage before they can add value. Now, it's really important, of course, but wealth management post-separation is often just part of the conversation. And it's further down the line, as I've just spent some time explaining, you know, by being involved early on, guiding conversations, financial planners can add value far earlier. That being said, post-separation, wealth management and future planning is still really important. So that could consider things such as retirement planning, potential inheritance tax planning, wealth management, to name a few. This is when a more traditional financial planning relationships tends to start. But as I've said, it's earlier in the process that I think a financial neutral can really add value. So that's me. I think I'm handing over to you now, Susie.
Thank you. So, thank you for your introduction, Sarah, at the outset. Yes, I'm back in Australia. My first experience with neutrals was when I was in Australia the first time, when I was requalifying, and I decided that I wanted to do more or less adversarial work, and I trained as a collaborative lawyer. And that was my first experience of neutrals. And neutrals is what I felt gave collaborative law the magic. I think that if those of you who are mediators or maybe have been part of a mediation may have recognized that what Sarah explained about the lack of trust from parties and where information comes from is very important. So if a suggestion is made for a certain outcome, whether it's financial or children, and it's children that I'm really dealing with today and that Sarah's asked me to address, if it's suggested, quite often we find that a client will say, has he suggested that? Has she suggested that? And I think what neutrals do is to provide information and expertise to the clients that the clients just take better than they would if it was coming from the other side. And having a neutral involved is just magical when that is a neutral that is in addition to the lawyers that are advising them separately. When I came back to England, having seen collaborative law at work with these neutrals who could get clients to agree to all sorts because they were suggesting things and clients were thinking, well, you know, I'll do it if that's what they think. It's not because it's what his solicitor or her solicitor suggested. I came back to England and realised that collaborative law wasn't quite as advanced. And I remember meeting Sarah at a pod meeting where Sarah explained hybrid mediation and not exactly challenged me, but it did challenge me when she said, well, actually, hybrid mediation, I can get people involved. So why would I need to train as a collaborative lawyer? Because here in England, I can do hybrid mediation and I can use neutrals. And she's absolutely right. And today isn't a day for me to talk about my love of collaborative law or whether it's better or worse than hybrid mediation. What that beginning conversation I had with Sarah showed to me is that both collaborative law and hybrid mediation, by involving neutrals, can have a real value. So today I've been asked specifically to look at the family consultants. Now, Under family consultants, I think really what Sarah's asking me to address, or what I am addressing, is the children's side. We've heard from the financial, from Adam, but the other issue, we have finance, we have children. And so who can we get that can be neutrals when the issues are children? Because people, and they're probably quite right, think, well, I know best about my children. Why would I need somebody to tell me what time my children should go to bed or anything like that? And that's quite right, of course. But so who are these family consultants and when do we need them? Do we only need them because we've got some special problems with the children in the case, or are there ways that we can bring them in any case where there are difficulties with children? Because again, when you suggest a solution for a family, no two families are the same, and Sarah's touched on that with her, and that's why mediation works, because nobody's telling the family, they bring their solutions, but they need information to do that, and they need specialist information that they maybe will hear much better from somebody who is not their lawyer, not a lawyer, and sometimes not even the mediator. And I think this is what interests me about using specialists for children in mediation. Because if we're honest, most of us who mediate in children cases are probably very able to give an early neutral evaluation in a case. But we're not really, especially if we're facilitative mediators, we're not really supposed to impart our own views as to what the right thing to do is. We're there to help the parties. And so I would suggest that we can use other lawyers sometimes. When you've been in the law for 20 or 30 years, as many of us have, we've probably got a good idea of best interests and what they are and what the research says. You can use other mediators, you can use therapists, and even divorce coaches if they've had a lot of experience. And I think, what are family consultants? Family consultants are people who can give an independent information to the parents, to both parents. And the importance of neutrals is that they're giving the same information to both parents so that there's no miscommunication. So they are people who you can bring in to provide both parents with a good idea, either or all, of what the court might do, of what generally best interests of the children are when people separate. In other words, the less conflict, the better, and all of that kind of thing. They can give advice as to what's worked in other cases. And as long as they don't give a view about this particular case or what should happen, what should be the solution, they are being neutral. And the parties will listen to them, probably be more open to what they've got to say than the parties would be if they're getting a letter from the other side, or even in a mediation, if the husband suggests something to the wife or the wife suggests something to the husband. So my own view of what family consultants are is that they are somebody that you select as the mediator, given that we're talking today about using neutrals in mediation. And one of the biggest and most important things I feel is that we need to have our network. Because you know the professionals that you deal with, and you know the ones that you would trust to advise the two parties that you're dealing with, the parents, mum and dad, what might good options be. And the neutral comes in and meets them. When should we use them? I think we use them whenever we're in difficulty. There may be straightforward cases that don't need neutrals, but whenever there's a difficulty, I say obviously, maybe more obviously, when there is a particular problem with a child. If there are problems, and a therapist could come in to be helpful, to assess the child, and then advise both the parents, give both the parents the same information about what the child needs. That's a more obvious case where a child actually does have a problem that a therapist could address. But they're not the only cases. I believe, rather like early neutral evaluation, you can use other lawyers or other mediators that you trust, that have got many years' experience, decades of experience, some of us have, to come in, meet the parties, meet the children if necessary. Usually you would want to use them some kind of independent social worker, or certainly somebody who's been properly trained. But there are some mediators now who are trained to be child inclusive. So again, it could be another mediator. But that specialist, that consultant, is not being a mediator in the mediation. They are being a neutral. And they are allowing you as a mediator to sit back and not have to provide that bit of evaluation that we all sometimes do in mediations about, well, perhaps this might be the better option. It allows you as a mediator to be truly facilitative and to bring in a consultant, a neutral, to do that evaluation. And so I think we should use them more often than we do. Who should we use? It has to be somebody you trust, because the one bad thing about neutrals, unlike normal experts, is that you don't have to and then assess who's good and who's bad. Once you've got that person in and they're giving that information, you have to rely on that. So you should use people that you know and that you trust to give good advice to the parents about what options are and what the best interests of the child require. How do you engage them? That's always a tricky one because of cost. But my suggestion is that when you are doing a MIAM, Sarah has very helpfully explained signposting. And it's at that stage that you can introduce the idea to the parents. And a lot of parents will have worries about mediation. They will worry that they're going to be bullied, or they will worry that their partner or ex-partner is going to be awkward. And sometimes you can use that worry to say, well, what if we get somebody in who will help you to make sure that, you know, they'll hear from you, and they'll make sure that what you've got to say about the children's needs is put forward. And so I suggest what can be done is that although it's an extra person to pay, and I think that's what puts people off, you can say that, you can explain that the mediation and the concerns they've got, which they may otherwise not then turn to mediation. And you can explain that if only they would put that investment in, then mediation could work for them. And finally, I do urge, and I do this when I'm doing my collaborative work as well, I do urge you not to be put off with parents that say, I can't sit in a room with him, or I won't be heard, or he will be this awkward. Because I do believe that mediation is still better than court, even for those people who have difficulties. And that's exactly sometimes where you need a neutral person to come in to spend time with both parties individually and together, to provide that balancing up that might mean that you can mediate where otherwise one or other party wouldn't have the confidence to, or maybe you wouldn't either. So that's what I believe, whether you want to call them family consultants or family neutrals, can do. They can come in and they can address, they can meet the children, set out options, they can set out the court's approach, assess and support the clients. Finally, there are some great divorce coaches out there who will support both parties. They understand about being neutral and they can provide support. I don't like to, I'm not going to name names on a webinar because it wouldn't be fair, but I think a divorce coach is one of those people, especially when it's not just about the children, it's also about how to communicate and co-parent. So I think that's most of the stuff that I wanted to say. And I can see that we're running out of time anyway, so I'm going to finish there.
Thank you, Suzanne. I think just touching on one of the things you said about a child inclusive mediation. I'm a child inclusive mediator, and before I qualified, I'd get someone else to come in and do the child inclusive pieces on my mediation. And actually, I think that sometimes works a bit better because you're not the one who spoke to the children, you're the one doing the mediator. An expert comes in, does it, and then disappears. And actually, I think sometimes when I've done my own child inclusive mediations, having someone else come in and do that piece of work really works. I think also thinking for other people that do that themselves, I do think that dynamics works quite well. Another thing that I just touch upon what Adam had said as well about the cash flow modelling, and one of the examples I've had of a case is where I was doing a hybrid mediation and one person came with a cash flow model on the day for themselves, and it just didn't work because we didn't know what information they'd put in there. We did. Husband said straight away, well, did she acknowledge that she doesn't need a 4-bed house when she gets to retirement age and children are grown up? Did she downsize? No. And it was just they'd spent £2,500 on it and we didn't even use it. So I think actually, I don't know what you think, Adam, but getting them together and talking about the different things that you put in the system to get that information out really helps than just one person going off and doing it themselves.
Yeah, definitely. I think, and it comes back to my point about getting involved early, because you could have told somebody early on, you know, we need to agree on these inputs that go into this cash flow because we're both making decisions on it, rather than one person going off and getting it and coming in and saying, well, I've done this. Yeah. I find that unless you've got people who have agreed within reason on the inputs that have actually gone into the cash flow, it just isn't anywhere near as useful. It's ultimately meaningless if you've not agreed on what's going in.
Yeah, and that's what I felt like. It was just a waste of money and we didn't even refer to it. And it was quite a nice, well-presented cash flow model, but it just wasn't used. I'm just going to get go through some of the questions that have got coming through. So if anyone does have any more questions, please pop them in. So someone's asked, do we have a list of reputable neutrals you could give us, which could be shared with parties? Unfortunately, there's not a list of neutrals, and I think what I've done, and Suzanne will probably explain, is that I've worked up for the last few years of people that I trust, and I think it's about going for coffees, you know, and keeping regularly up to date with, you know, a financial planner, a divorce coach, and just build up your own connections, and then think about what you want to do and send out to your clients. There is obviously, if you're a mediator and you're part of member organisations, there will be lists probably with them of people that they recommend or people who've done training and things. Do you agree, Suzanne? There's not sort of like a list of anyone, but I think that's the relationships you build up with that individual, isn't it?
That's absolutely right. And what I would say, you know, it sounds like a cop-out, but what it needs you to do, it's the signposting that Sarah so helpfully said. You need to, as a mediator, go through that signposting, not just with the client, but with yourself, and think, who can I think of in my professional sphere that would be able to advise these people on this particular issue, and who would be able to advise these particular people, because it's horses for courses. You know, those of you solicitors who you know, use barristers. Sometimes you don't use the same barristers because you need a different approach. So I don't think it's a list. It's about you signposting to yourself, or who in my professional network would I like with me? Because you're working as a team. Who would I like with me advising this couple?
Yeah, and I think as well as a solicitor, I do refer out to mediators, and I know lots of mediators, and I don't just have one. I think about that individual person who would gel with that other person. Same with financial planners. I think, well, who would be better with that person? And if you get to know people and go out and meet people and hear about what they do, because like you touched upon, Suzanne, divorce coaches, different ones have different things that they will do. Same as a mediator, I have different processes, and it's about getting to know people and making sure it suits. We've had some really good questions through. We've got another one. What are the implications for the financial neutral and or the mediator when gaps in the financial disclosure are identified? The gaps either have been overlooked or intentionally left out. I think this is where it comes back to the financial disclosure, and like Adam was saying, he could help with the forming as well, and the mediator looking at what financial disclosure is required and pointing out that if you was to go to court, you would be, you know, that is the information that you would provide. And then it's about having the solicitors involved in the outset. So I'd always say, go speak and get legal advice if there's things missing out, because I can't say that, but you need the solicitor's support. And then if they do reach an agreement and I know something's missing, but they still want to proceed, for instance, if they haven't wanted a pension on divorce expert, I would put on my memorandum and standing at the bottom that both parties were very clear that they didn't want that. So equally, we can't, you know, that's the problem, and pointing that out. But it's in mediation, it's the parties that make the decision. So, you know, we can only just point them in the right direction, but it's up to them if they take that on board. I don't know if either of you to have anything to add on that one.
I agree, ultimately. There is only, if somebody doesn't want to disclose something, there's only so much you can do. But once we have an idea, from a financial perspective, once we do know what assets are involved in the pot, as I mentioned, you know, we can write off to providers, we know what questions to ask. So ultimately, as long as we know that the asset exists, we can then go and find the information that we need, or speak to a professional that understands, again, from the tax perspective, for example, what we're looking for. So things aren't missed, or they're less likely to be missed, because, you know, we know what we're asking for, relevant for the situation.
And I think one thing as well, just to add there, is if I was doing a mediation and the husband or the wife are refusing to disclose a bank statement, and I would say mediation is no longer suitable, because you need a judge then to make that indication and make them. So there's also that point that as a mediator, if you start alarm bells ringing because someone's not disclosing something, the trust and confidence has broke down, and mediation is probably not the right way to deal with that. So I think that's an important part. Another one's come in saying, would it be possible or appropriate for a financial advisor, a planner, to go through mortgage capacity with each individual within a session so that affordability can be looked at?
So it depends what the financial advisor is regulated to do. So as a financial planner, I'm not regulated to give, and this is just me personally, I'm not regulated to say, you know, this type of mortgage is available to you. You know, you need to go to HSBC because they offer the most competitive rate. That would need to be a mortgage broker. However, as a financial neutral, we can comment on the kind of ultimately what's possible for a mortgage. So a broad idea, if your income is X, the likelihood is the mortgage you will be able to get is going to be around Y. And then we can have a conversation about how, you know, mortgage payments will fit into ongoing sustainability of spending, which we can then put into the cash flow. But specific mortgage products, again, when you're actually going to the particular lenders, would have to be a mortgage broker. So just to reiterate that, so a financial advisor could have kind of a general conversation about, you know, the pros and cons of having a mortgage, taking on debt, what that has, the implications that has, but the specific mortgage that would be available, and potentially, you know, the specific cost of that, a mortgage broker would be the person who'd be able to give that specific cost.
What you can do, and I've done it before, is you give information to one specific mortgage advisor company, and they'll do a letter that's used in court, and they'll do it for both parties, but they'll do that outside the mediation and separately, and then send it in, because there's no point using the time of the mediator to go through mortgage raising capacity. We need to look at the best use of time, and sometimes it might be that if Adam needed to speak to him about pensions and I didn't need to be there with the neutrals, you need to think of when we all need to be there and when separate meetings take place, just to be a bit more cost effective. Someone else has said about what's the approximate cost, Adam, for cash flow modelling?
So obviously it's case by case basis, but I would say typically from experience, from about £1,500 plus VAT to about 4,000 plus VAT. Once we've got an idea of the complexity of the situation, again, once we've met with somebody for the first time, we've asked some questions, we can start to get a pretty good idea of what the cost and the complexity is going to be. But yeah, it's a range, but I would say from my experience, 1,500 plus VAT for a simpler one, to up to 4,000 for a more complex one that might involve more meetings to kind of go through it and agree.
Thank you. Just quickly got a few more questions. Sorry if we've not been able to address them all. Someone's put, do all neutrals need to sign the agreement to mediate? I would always get the neutrals to sign the agreement to mediate. When Adam comes in on Monday, we're getting him to sign it as well, that we all have that confidentiality and if there's any complaints and things like that. So yes, it's important to get that done. Someone said, have you involved a neutral in drafting an instruction letter using the neutral's experience to ensure that all aspects of which advice is needed are covered? Their experience is that instructions letters sometimes need and to elicit the information needed, and getting it right first time can save a lot of time and money. Suzanne, I don't know if you can sort of shed some light on that. I think I've not done it as often, but I think if I'm right, that they can assist in the terms of it, but then it needs to be done separately, not as the neutral sending it out, so to speak.
Yeah, I think the neutral assists the parties by sitting down with the parties, either together or separately, to make sure that both parties' views are known. And then the neutral is a very good person, actually, to assist to make sure that both parties' information and views and needs go into it. But finally, the person that finally sends it off is either the mediator or the parties. But it certainly assists along the way to make sure that both parties feel that their side, as it were, has been incorporated.
Yeah, so I think if we was doing, if Adam was assisting me doing a letter of instruction to a pension expert on divorce, and we're getting the actuary, that he would help us about what we'd put in that letter. But in terms of actually formally drafting it and sending it off, I don't, is that overstepping it a little bit, Adam, with you? Would you'd assist with that?
Yes, you've got to be relatively careful with it, but we can certainly help to guide what goes into that instruction. I know there are pension specialists available that can help. I know Mark did a session earlier this week on making sure the right information goes in so that you actually get something out that's relative to the client situation. But we can have those, again, general conversations about, okay, well, when do you want to potentially equalise benefits within a pension expert report, i.e., how does that fit in with the couple's retirement goals, rather than just saying, well, it's going to be 67 because that's state pension age. So yes, we can absolutely help, but actually drafting it, there's a certain amount that they need to do, and we need to be neutral on.
Thank you. Right, we've run out of time now. We've got it's been really good speaking to you, and thank you both for coming on. And I think hopefully we've triggered people to be thinking a bit more outside the box and food for thought, and about different people and how we can all help, and different skill set. There has been other webinars throughout this week of Family Mediation Week about neutrals more specifically. And hopefully we'll be sharing videos from last year's Family Mediation Week that were also touched on that. So please keep an eye on that. We've got a YouTube channel on Family Mediation Week. Okay, thank you, Suzanne and Adam. It's been lovely to speak to you.
Thanks a lot.
Thank you. Bye.
Bye.